So let's speak to Joseph Kotrie Monson. He's a criminal defence lawyer in Fleet Street who specialises in sexual offences. What do you think of the Director of Public Prosecution's suggestion?
Afternoon, Ian. Well, I think it's important to place in context, first of all, who Alison Saunders actually is. And that'll help us understand why the basis of this revelation, if you can even call it that, is actually somewhat short on substance. Now, Alison Saunders, as we know, is the Director of Public Prosecutions, the head of the Crown Prosecution Service. She has no power to make law on evidence. That is Parliament's job. In criminal cases, whatever evidence CPS lawyers bring to court is subject to the rules of evidence and the types of things we've talked about. Is the evidence relevant? Can it be admitted? And actually, with respect, you're actually wrong to suggest that in more, or if the suggestion is that there are more cases where the complainant's sexual history is brought up than the defendant's history. Bad character, as we call it, and that's wrongful doings in the past by the defendant, is overwhelmingly used in these types of cases and criminal cases. It's very rare, and the barrier is very high to somebody's sexual history being brought to court if it's a complainant. But the crucial point here is the evidence that they obtain anyway. It's not obtained by CPS lawyers. They're not the investigators. That's the job of the police. And I have to say that for us, as a specialist firm in this area, we can tell you that certainly in England and Wales where we practice, every police force, and I think it's police who must be most offended by these comments because they are doing this exceptionally well already. Every police force has at least specialist, highly trained detectives who've been doing this stuff, looking at Facebook, looking at social media, looking at background for years. It's the basis of high quality policing. And in fact, most of those police forces even have specialist sexual offences units, which are streets ahead of anything that Alison Saunders is saying here. So what she's actually saying is she's going to tell her lawyers, who are not investigators, to look at things that it is the police's jobs alone to look at, and that they're already doing for the most part, despite the limited budgets they have very well. And frankly, I am a defence lawyer. I am so often in opposition to police officers as part of my job. If I was a senior or an experienced police officer who was experienced in this area and highly trained in this area, I'd frankly be a bit offended by
this. All right,
this.
well, if there's any police officers, again, you don't have to use your real name, who've been involved in this thing, if you are a specialist, what do you think of Alison Saunders, the Director of Public Prosecution's suggestion? So what is the law about bringing up a defendant in a rape trial? What is the law about bringing up their previous sexual history? Are we allowed to talk about previous convictions, for example?
Yeah, well, in any case, the first barrier that for any evidence on either side to be advanced and heard before the jury, for that evidence to be admissible, that means be allowed, it has to be relevant. And the test for relevance is it has to tell you more about what might have happened, tell the jury more what might have happened, than be just prejudicial. So just mudslinging, saying, well, this person did something naughty sexual, if it had no relevance to the allegation, wouldn't be relevant. But against a defendant, there is a principle generally that bad character, so that's wrongful doings by the defendant, is not what should decide the trial against them. That doesn't mean that bad character evidence, that evidence of wrongful doing in the past, is completely out of the window. Criminal Justice Act 2003 allows in certain circumstances, and the bar is relatively low for that evidence to be in. The question is, do the police have access to it? Because if something is going to be relevant, if somebody's been in a coercive relationship, if somebody has acted in a way sexually that kind of indicates a controlling element which is consistent with the allegation that's made here, not just controlling, but relevant to this allegation, generally speaking, it will be admitted.
She seems to be suggesting that with such a low conviction rate, 23,000 rape cases in a year, less than 3,000 end with a conviction, she seems to be suggesting that a lot of people are getting away with this. Now, obviously, I wouldn't expect you to agree with that because you're a defence lawyer.
Well, I hope I'll give you a more impartial view of it.
Go on then, give me an impartial view. Do you think people are guilty and getting away with this?
I don't think she's in a position I don't think she's in a position to answer to deal with this. That has happened on her watch. by addressing to CPS lawyers things that are in the press that we all know should be happening, that police are doing anyway. I think one of the major problems with conviction rates, I think that in an ideal world, conviction rates are definitely too low in rape cases. There's something you wouldn't expect a defence lawyer to say, Ian.
I'm shocked.
But the reason is not because of the evidence or the evidential rules. It's because sex is inherently a private thing. That therefore means that it's usually one person's word against the other. And because in our courts, in our legal system, we believe in innocent until proven guilty, sometimes it can be hard when one person is saying the opposite of another person, unless you've got extra evidence, which we've described. It's not like you're going to often have eyewitness evidence of what actually happened. Getting over that, not just innocent until proven guilty, but beyond reasonable doubt, so the jury have to be sure, which I think we'd all agree is a cornerstone.
It seems to me that the key point about whether someone's guilty or not is what does consent actually mean? That's the key to this, isn't it? It's like in cases where if they're both intoxicated, you probably thought, yeah, consent was given. It's like, well, that's the grey area. One person may well have thought it was fine, and the other person the next morning thought it wasn't.
It's so difficult, and it's the reason.
If someone's screaming, "Get off me! Get off me! Get off!" There's no dispute. It's the grey area, isn't it?
Well,
the problem.
The problem isn't necessarily. I think, with respect, the problem is not that we have a situation that people don't know what consent is or the grey area. The problem is it's nearly always one or the other. It would be clear to any bystander who could provide the evidence, but because this is a thing that usually happens only between the complainant and the defendant. We don't have that corroboration. No. That will always be the problem. You can try and dress up the rules and grandstand and do newspaper articles saying, oh, we're going to clean up this and clean up that, but you're never going to get over that major problem. It's frustrating as that is.
I'm sure. But just a very quick answer on something that's related to this, but while you're on, I'd like to ask you, speaking to a criminal defence lawyer about rape trials, sexual trials, do you believe that the defendant should have more anonymity up until perhaps they're convicted? Because we've seen this before, haven't we? Their name is splashed all over the papers and they're actually innocent.
Very, very difficult question, one that's been covered on this show very well in the past, or this station very well in the past. It's very difficult. Serial paedophiles on the one hand, you get one allegation, and then other people who have been unable to deal with the fact that they were abused by this person, see it in the press, and then come forward and make genuine complaints. On the other hand, isn't it the case that mud sticks, and this is something that is so egregious that somebody may never truly recover, when it was obvious to the jury by the time the case got to them that this is a person who always should have been acquitted.
Yeah.
Very, very difficult. I think there's a need for reform. I don't think the answers yet are clear as to exactly what that reform should be.
Brilliant. Thank you for talking to us and explaining some of that. Was Joseph Kotrie Monson. He's a criminal defence lawyer at Mary Monson Solicitors in Fleet Street. They specialise in sexual offences. So he obviously doesn't have a great opinion of Alison Saunders, the Director of Public Prosecutions, but I guess she's the enemy, isn't she, in a way?